and I'm not sure we have the authority to do this, but to make a finding regarding what Mr. Henderson has described as protectable property rights. And does the board even have the authority to be able to make rulings on what are being presented to us as private property rights, or maybe legal right of entry and so forth? And in other cases that we've heard recently, it seems like the legal right of entry is at issue, and yet it seems like this board is not the appropriate agency. And I've expressed this myself, that the board is not the appropriate legal entity to determine legal right of entry. And it seems like, do you see where I'm going with this? I mean, do we even have the legal authority to make a ruling that these protectable property rights exist and should be taken into consideration by us? Or seems to me like maybe these issues are better decided in the district court rather than here.
Yes, to answer the question, Fisher, and to the extent, Mr. Roberts, I don't want to get too far outside the scope of the original question, but to answer that question, yes, the position of the division has been, we cannot adjudicate private property rights. We are without authority to do that. I believe that also extends to the board. We don't determine who owns the property when there is a genuine dispute with that property right. That said, to the extent it relates to or is relevant to the establishment of party status, I think that likely does fall within this board's jurisdiction. And I know that Mr. Henderson would like to supplement the record with some of the discussion on this very point. I'm not sure that the division is disputing some of the property rights claimed by the petitioner here. But I think it is clear that throughout the course of the last year and a half, there have been legal right of entry problems. There have been genuine disputes over who owns property. They have been litigated in Jefferson County District Court. The division has done, I believe, a commendable job of allowing that court process to see its way through, to help provide some clarity for the division as to who owns the land with respect to right of entry issues, who may own the property. And we're also seeking some clarification, not as a party, but just as an observer from the court on the financial entity itself. But I believe the division is correctly for that type of adjudication of who owns what to prevent litigation.
Any more questions on the council for the staff? Okay. Mr. Henderson, I'll give you an opportunity to respond specifically to the legal issues of jurisdiction and party status.
Thank you, Mr. Brubaker. And part of this goes in answering Mr. Fisher's question, that being that with regard to the argument I was making, the reason that listed protectable property interests was because that's really the first step in a due process analysis. What are your protectable rights, constitutional or otherwise? Quite a broad array of those in Colorado. Liquor licenses, in fact, and the second part of the inquiry, if you have protectable property interests, is what due process is appropriate. And essentially what division staff and its counsel are arguing is that notice by publication, in this particular case, it was the Denver Daily Journal about 12 days before the hearing, which I would certainly agree with regard to it under the rules, would have been appropriate for a citizen at large, but not appropriate for those with protectable property interests and permit in the bond. So in the first instance, that protectable property interest list, which I gave you, which is pretty extensive, is the first step in the due process analysis. The due process then is needed is situational. Due process that might be appropriate for a citizen at large to comment versus someone who has an interest in a $500,000 bond. Let me give the board an example of what I'm talking about.
Can I
Yeah,
interrupt
sure.
you? I don't hear your argument on our jurisdiction,
Okay.
and I don't hear your argument on based on our jurisdiction to go back now and try and change the order, either by providing party status or by reconsidering our order, can't be done. We cannot do that is their argument. Now, what's your argument? Are you saying we can? You already filed the lawsuit, and what our lawyers are saying, once you file the lawsuit, we don't have any authority.
And one of the defenses to a lawsuit in administrative matters is a famous doctrine called exhaustion of administrative remedies. And it's a question of whether we, as the potential petitioner or as a claimed party in interest, pursued the administrative remedies, or all the administrative remedies that were available to us prior to seeking review by the court. So in my view, in remembering that the decision, I don't think was formally published in the December decision until perhaps early January, our deadlines for doing these things are pretty short. Set a deadline for moving for reconsideration. There's another deadline for seeking review before the district court. And I have to meet those deadlines, and I have to be aware that the state and its attorneys may well use an exhaustion defense against me. So I wanted to make a very clear record that, yeah, I believe you can do this. You have to listen to your own counsel. Because I think you could move the issues that are before the district court by taking the actions I request. If you listen to your own counsel and you have been deprived of jurisdiction on both issues, I certainly want to make a clear record. Because here's one of my concerns. I'll express this in 30 seconds. Starting in 2015, there was extensive correspondence and exchange of documents between the division's attorneys, and even the advisory attorneys in the Attorney General's office concerning, in the first instance, the status of our levy and execution on the bond. But before the transfer of operator was denied in April of 2016, in March 2016, Mr. Ken Beekler, attorney for Pride of the West, wrote a 3-page letter to Mr. Fugate outlining every single legal step that had been taken and then giving the legal analysis for the nature and extent of property rights that have been achieved by Pride of the West, and copied all of the documents from those proceedings sequentially into his letter. I'm not even aware if that's in the file, if it's in the permit file, or whether the board was even aware of it. So at the time that Mr. Hennix appeared at the December hearing and requested to speak, he wasn't really coming in as an unknown third party. As a matter of fact, it had extensive and relatively constant contact with staff and with his attorney with the staff. And we think that we should have been notified, both Pride of the West and its counsel, at that time was Mr. Beekler, with regard to the hearing concerning revocation of the permit and forfeiture. And this is a major impact on Pride of the West. Just looking at one aspect of that, the financial warranty, you've got a bond of just over $5 million in cash bond. We estimate that remediation of cell 1A, probably somewhere in the neighborhood of $35,000 to $50,000. Just accept that as my argument. With a full revocation of the permit and full reclamation of the site, you've got a $500,000 bond sitting out there that is potentially going to be exposed and fully absorbed in reclaiming a site that, frankly, we would prefer not to have reclaimed for the active of the permit. So just that difference between $40,000 or $50,000 and $500,000 just on that one property meant that Pride of the West had very,
Excuse me, but I understand you're making your record. And I think I've heard your argument, and I think I've heard enough. But you can go on if you want to create your record. But when you start introducing all these facts, I don't hear that telling me I got jurisdiction.
Well, I do have to make my record because I'm now even more concerned than ever that the board was fully aware of the status of private lots at the time of the hearing.
Well, my personal opinion is we were fully aware of it at the time. We were aware that there was no status.
Because there's no question that legally, Pride was not yet the permittee. We had not achieved the transfer, and the division was requiring signature.
As I see it, I'm probably making more of a record than I should, but as I see it, we administer permits. We don't administer property rights. And we know who was the permittee holder at the time of the hearing.
Well, and we're not asking the board to adjudicate or to administer property rights. I mentioned those things only for the purpose of when it comes to the constitutional issue of due process. The nature of someone's protectable rights determines both their status and the nature of the notice and the right to be heard that is appropriate under the circumstances, given the tenor of the rights to be protected. Our point for our own record would be that with the permittee, it was at that point only one party in interest, that we were, if not the only party, we were a party in interest. It should have been treated for purposes of notice and opportunity to be heard of having the status of a party. The board might have decided the same thing. We will never know because we were not allowed to make the record, and that record was going to include an offer of remediation that I think the board would have found attractive.
And it sounds to me like you've asked the court to make those decisions by filing a lawsuit.
And we have brought it here to the board using the remedies that appear to be available to us under the Hard Rock rules. And if we fail to do that, I'm sure your attorneys would likely try to use it against me in the district court. So I'm doing everything I feel that we have to do to make it clear what the situation is and what it was at the time of the hearing in December. And I certainly would move that you consider exhibits 1 through 17 as submitted in making the record, as well as our oral statements. Mr. Dennis, is there anything that you would like to further say that would supplement that?
No, we're just not trying to embarrass anyone. We've had a solution in hand. We're trying to basically make it easier for everybody.
And we will continue to do that.
Does the board have any questions of a jurisdictional nature for Mr. Henderson? Okay. Anybody have any questions for me?
Do you have an?
What's our jurisdictional term?
Yeah. The cases cited by the division's counsel are longstanding, and there's not a factual question. It's a legal question of the fact of the filing of the judicial review action immediately deprives an agency of the ability to substantively modify an existing agency order. I'm not aware of case authority on the particular issue of retroactive granting of party status, but it would be my understanding, and Jill, if you have a legal issue on this too, I'd be open to hear it. But retroactively granting party status to a previous hearing from which that board order emanated, and even for the possibility of considering whether legal or property rights exist, that would constitute a substantive modification of that standing order, which I just mentioned that if the jurisdiction has been transferred to the district court, that's where it stays. This board doesn't have authority to touch the order in any way, which would include retroactive granting party status.
Questions? Motion?
I'm not sure what type of motion we're looking at this point. Whether we go forward with the hearing, whether we deny, what exactly are we making a motion on?
So before the board today is a joint petition or combined petition for reconsideration of the order that came from the December board meeting and a declaratory order regarding Pride of the West and, as I understand, Mr. Hennis. That being that he had a recognizable party or property interest that would justify party status in that hearing that occurred in December. So your motion could be to deny the petition. As far as the petition for reconsideration, if you choose to make no motion, then it will be deemed denied as a matter of law. It'll just by not taking any action, it'll go away. So what you could do if you agree with my legal analysis on the petition is you could choose to make no order on the petition for reconsideration and deny the petition or that part of the petition that seeks a declaratory order.
Okay. I move that we deny the petition seeking declaratory order under Rule 2.5.
You need to consider, also reconsideration of a board order on that motion.
John said I do not need to take action.
Yeah, just to reiterate, under the rules, the board not taking an action on a reconsideration motion or reconsideration petition, excuse me,
Okay.
will result in it being denied.
Okay.
I'm not even sure, to be honest, under what the case law is, that you have authority to grant or deny it, because denying it, you don't have a jurisdiction to even deny it. So that's what I'm thinking. Where proper course is to make no formal action on the reconsideration part.
Second motion.
Moved and seconded. Any more discussion? All in favor? Aye.
Aye.
Thank you.
Thank you.
You want to try and push through the executive order?
Oh, yeah, just for
Executive session.
everybody's here, and I've already mentioned this to a couple of board members. I have another board meeting at 1 o'clock. I guess I'm in high demand today, but it's all the way across the park at Dora. So it's the board's pleasure whether you wish to push through, but where we are at 12:45, I will need to leave.
Push through? Okay. Do you have my motion?
We are on the NOIs.
Are we?
I think we are.
Number 7.
Oh, public comments next, I guess. You don't
Okay.
understand why the agency can't change?
Yeah. Yeah, at the same time. Yeah. And we've argued this issue before with.